Good evening, everyone. I hope you all are doing great and are as excited as I am to embark on this incredible learning journey. On behalf of Legal Vidya, I, Khushbu Chawla, welcome you all to the live webinar on Insolvency and Bankruptcy Code 26. Before we dive in, let me extend my heartfelt gratitude to each one of you for trusting us and choosing Legal Vidya as your learning partner. We promise you an enriching and transformative experience that you will expand your legal knowledge and prepare you for the real world corporate challenges. To kickstart today's session, let me share a bit about who we are and what we stand for at Legal Vidya. Legal Vidya was established in 2021 with the mission to revolutionize legal education through the power of online learning. We are more than just an edtech platform. We are a community of passionate learners and legal professionals. From internships and workshops to webinars and comprehensive courses, like the one webinar you have joined today, we offer a wide range of opportunities to help you grow in the legal field. What makes us unique is our focus on not just theoretical learning, but also the practical application through real world case studies, discussions, and mentorship. This webinar on Insolvency and Bankruptcy Code 2016 has been meticulously designed to give you a 360-degree understanding of key provisions of OPC and practical guidance on corporate restructuring and liquidation. Over the next few minutes, we'll cover key provisions of IBC 2016, insolvency resolution process, role of NCLT and NCLAT in adjudication, latest amendments and judicial interpretations, strategies for advocates representing clients in IBC matters. Through this session, you'll gain an insight into real world scenarios and practical guidance on corporate restructuring. Our primary objective is to help you build a strong foundation in IBC, understand the different roles of NCLT and NCLAT in adjudication, get a clear idea of practical corporate scenarios. By the end of this webinar, you will be equipped with the skills and knowledge needed to understand IBC 2016. Now, let me introduce the person who will lead this amazing journey, Advocate CS Avdesh Kumar Varshane. He is the founding partner and mentor at Justice Wing Solutions LLP, also XPWC Trilegal Dheer and Dheer Associates, Fox Mandal. He is also a specialist in corporate advisory, contract drafting, insolvency law, and dispute resolution. He is also a member of Delhi High Court Bar Association, Supreme Court Bar Association, and last but not the least, Indian Lawyers Association. To begin today's session, Advocate Avdesh will introduce us to Insolvency and Bankruptcy Code 2016. This foundation will set the stage for more advanced topics we'll explore over the next few minutes. Feel free to actively participate, take notes, and ask questions after the session. Remember, your engagement will make this session, this learning journey, all the way more impactful. Now, without any further ado, please join me in giving a warm virtual welcome to Advocate Avdesh. Over to you, sir.
I Thanks for the introduction. This is Said. There's some technical bug I'm just trying to identify with regard to the camera only. Yeah, hope I'm visible now.
Yes, sir, you are visible.
Yeah, there's another laptop, but anyways, I've logged in the other one. So you've already appraised me and just get into the PPT. I'm just opening the PPT. Just give me a moment, please. So before I speak about the PPT, just wanted to have a clear understanding. Uh, what is the audience means? Is it the student group who has a basic understanding of the IBC, so that accordingly I then shoot on the PPT, or is it all fresher? Means who's the target audience?
So basically,
Hello.
we have all type of students as well as practicing advocates in this webinar.
Okay, perfect. Nice. So before I begin with the PPT, I just give you idea how the IBC came into play, because to understand a particular act, you need to understand why it has come, and then you deliberate more on what are the positive, negative, and all that. So Uh, see, prior to the IBC, it was surfacey, and prior to surfacey, it was recovery to the banks under 1993. So, what used to happen in DRT Act, whenever there would be any due of any bank, they would file an application to the DRT, and then possession they would be able to take. Post that, the surfacey came in 2002. SurFaci was introduced with the objective uh, that the bank do not have to go to the courts to take over the possession of the property. They can under 13(2) can take over. Then the 13(2) under section 13(2) they can send a notice within 60 days. Thereafter, they can take the possession. And post that, even on surfacely, the need was felt that it was still not able to support the banks as it meant to be. And with that motive, the IBC came, and then it is happening from last 4 or 5 years. 2016 it came, but it started in 2017. So the today's presentation, I'll take you on twofold. One is I'll give you background of the IBC, both in IBC, it's a code actually. So we have the CRP regulation wherein the company from the starting, when it's not able to pay the money to the revolution, and the second is when nobody is willing to buy the company, then company gets into the liquidation. Apart from that, personal insolvency is also there under the code, which will not take up because the time is constrained here. We are sitting at 508. The idea is within next half an hour, I'll run you through the CRP process and the liquidation process, and post that to give you practical way of how to navigate on the IBBI website, and take you to the website itself. So here I take you to the presentation. Uh, I'm audible and visible, and my PPT is also visible, right?
Yes, sir, it is visible.
Yeah. So presentation on IVC overview and practice area for advocate. And meanwhile, because I believe most of you are in the law school, your idea would be to understand from the advocate standpoint what are the opportunities for an advocate. On that basis, I'll keep on pitching you that what aspect you can speak with the client and wherein you can find your practice areas. So now to start with, application of insolvency bankruptcy code under section 2, these are the parties who can file a CRP application. One is the company itself, the other is any body corporate, LLP is also covered. Personal guarantor, I'm not taking. Partnership firm and individual, they get into the DRT, which we are not discussing at this juncture. And once this application, there's a threshold. It is not for any work of 5 rupee, 10 rupee you can file. So in India, as I if I speak about India, there are two mechanism. One is you file a recovery suit. The other is you when the amount is acknowledged by the other party. There's a winding up provision also under the Companies Act that you can file. And apart from all of these, the CRP application is one thing people can try, and the minimum threshold is 1 lakh. It used to be, but then the central government in the COVID time they increased it to 1 CR. Now the threshold is 1 CR. The debt, if any party has a debt of more than a 1 CR, it can file to the particular adjudicating authority, which would have a jurisdiction over the registered office of that company, right? So wherein you can file an application, and uh, one and it can be filed by any particular institution which has granted facilities loan to that company, or it can also be filed by a operational creditor which has given goods or services to that company. Or lastly, a corporate debtor under section 10, they can also file an application against themselves that they believe that they're losing on the value, and they can also file. So at this junction, initially, because I've been working in this domain predominantly, so I can also give you the background. Initially, it was more push from the banker side. Bankers were more filing the Section 7 application, but at this juncture, you see more application coming from the debtor side. And this is a scenario that once if operational creditor is filing, then they have to issue a notice of 10 days prior to filing an application, which is a mandatory condition. And for Section 10 application, the special resolution is required from the shareholder. It is not at board discretion, it is a shareholders company actually. So that's the idea. And once the company get into the insolvency, it can always be taken back. So before we take, I talk about taken back. So once the company get into a CRP process, the idea is anybody, a financial creditor, operational creditor, or maybe company, they filed an application. NCLT by large take, though the code provide 14 days, but by large it takes 5 months to 1 year to adjudicate upon that application. So once that application is admitted, then the process is start. So now we will be talking about the process. So before process, this is the step. You file an application, NCLT deliberate, give the chance to the corporate debtor. You also put a reply, listen to both the parties, and once it is made out, then it is admitted. And as per section 12, the process of the CRP has to be completed 180 days, which is the time duration. So in nutshell, if I just explain you the CRP process, now you understand. You have given some facilities loan to somebody. That's the general scenario. You have given a loan to a particular company, but then that company is not able to pay your EMIs. What you will do? You will try to take over the possession, whatever security you have given to me. So the same way, bank in the CRP process, you will find the one which is controlling the company is the banks. So banks through the RP, because bank is a multiple bankers, they have advanced the facilities to the company. So bank through the RP, he take the possession, and then he run the affair, then find a suitable buyer for a company, sell that company to that buyer. That's the in simple one line. That's the procedure. If somebody asks you what is the procedure, application admitted, IRP appointed. His job is to take control and custody of the asset of the corporate debtor, and to find a new buyer who is willing to pay for the asset. And the banker's discretion is to find the best buyer. In nutshell, that's the procedure. But anyway, I'll take you to the detailed steps. So once the company is admitted, within 180 days, they have to complete the process. And now there are two things. One is the IBC Act itself. Apart from that, the CRP regulation. So somebody who is running the CRP process, he has to be aware of both. At least these two. Apart from that, there's rules also. There are multiple notification, guidelines, circular, all put together. Then you would be able to run the process. And once the process has started within on, before the issuance of the EY, with 90% of the consent of the COC members, the process can be taken back. Means it can be agreed to a OTS, which is one-time settlement with the bankers, and the process can be quashed. And as I was saying that once the application was is admitted, the IRP now, to also give you a practical scenario, some people believe that after their advocacy, after completing 5 years in law, 3 years in law, they might go for a practice of IEP insolvency professional. So at this juncture, there are two ways. One is you with 10 years criteria, you can appear for that limited IP exam and then get the IP enrollment. The other way is the IBBA has itself introduced a program wherein you can enroll for that program and then practice as a IP if you qualify that examination of the. For that there is no criteria of 10 years. So once the application is admitted, the court appoints somebody who is a registered member with the IBBI. He runs the show. He is appointed, and within 14 days, he is appointed, and within 30 days, he had to hold the first COC meeting. So uh, once he is appointed, he would put a public announcement. And the day the company gets into the CRP, the moratorium is applicable, which is there on your screen. So, what is the meaning of moratorium? That uh,
Sir, I apologize to interrupt, but can you just reshare the slides because they are not moving, and also if you could just present it
my
on.
slides are not moving in.
No, sir.
It is still frozen on the first one. Yeah.
Yes, sir.
Oh man, I have moved to the 14th. No, it is. I think it's on the screen is ninth slide coming. Moratorium under section 14.
Now, sir, it's visible.
Okay. Now, is it visible?
Yes, sir, it is.
Is it moving now in your screen or is it not moving?
It's stable on point 0.9.
It's moving in mine. So how do we do that?
So you can retry sharing, like stop sharing and start again. Maybe it will
Yeah,
be.
I do that. Then that's the only option. Is it moving now?
Yes, sir. Now it's on point 0.7. Yes,
Okay,
it's moving.
okay, I do this way. Perhaps. Is it coming on the full screen or what?
No, sir, not on full screen.
Now is it coming on full screen?
No, sir.
Is it better now? What?
Yes, sir. Now it's better.
Okay.
You can switch to presentation mode,
Yeah, that's what I've done.
but it's fine, sir. I hope everyone is able to see it. You can
Okay,
react, please. Okay. Yes, sir. It's fine. Great.
thanks. Yeah, it was on presentation mode only. Yeah, nine. Is it moving now? No,
Yes, sir. It's fine now.
it's moving. No, slide is moving.
Yeah. Now it's on 9th.
Oh yeah, it's again the same issue.
Yes, sir. It's moving.
No, no. See, once I exit from that scenario, it moves. Once I put on the flight plotter view, it is not moving. So that's happening. But anyways, I do not put on the slide sorter. I just do it normally then. So now I think it should be moving. We are on public announcement, right?
Yes, sir. Yes.
And screen is visible by large, right? Yeah.
Yes.
So yeah, once a company get into CRP process, the moratorium is applicable. You might have heard this term moratorium. What is this moratorium? Moratorium is nothing but any party who want to take action against a corporate debtor, they are embarred. They cannot proceed with the action against a corporate debtor because that's what the moratorium means. In nutshell, however, if you go with the explanation, it is the institution of the suits, continuation of the pending suits, transferring or encumbering. It is basically no value of the corporate debtor should deteriorate till the time moratorium is applicable. And during the moratorium period, the corporate the creditors who are providing you essential services, they cannot stop. And so these things cannot be stopped. So I was intimating that once the RP appointed, he first in initial 2 3 days, because we have run this process multiple times, in first 2 3 days we intimate everybody this company has gone into insolvency, even to ROC, to if the company is listed on a stock exchange, to stock exchange, to the bankers, everybody that this company has gone into IBC. And officially, after 3 days, we have to make a public announcement under Section 15. And with public announcement, we are intimating people by large. As in law, you would also understand anything happens. The mandate provided under particular act would be that you make a public announcement, even with uh, absconder, offender. That's how everybody is made aware of that this is happening. Though nobody in this time is, at least the college student don't read newspaper, but that's how the information become public. Once he has to do this public announcement within 3 days, and once the public announcement is done, it is assumed that the people who has a claim against that company, they would be filing their claims to the RP, right? So once the RP gets the claim, he then do the verification of the claims within 7 days. And then within 21 days, he has to formulate a COC. COC is nothing that a committee of creditors who would be giving a guidance to the IP. So main decisions are taken by the committee of creditors. It is by large the banks only. Banks nominate some people from their panel, and then those people are sitting in the COC meetings, and then they help the IP to run the process. Decision taken by the COC. Apart from now, in as I was saying that IBC is a code, everything is provided. If you get into the code, everything, even detail when he will take a breath, that's also provided, not in the literal mean, but what all activities to be done and what in what time duration, everything is provided. And categorically, section 28, it talks about which are the power of the COC wherein their consent is required. It is not that IP can do those decisions on his own. So, and as I was saying that the procedure is public announcement, and you have to find a buyer. To find a buyer, you have to have uh, provide some information. That information is provided through information memorandum. Now, information memorandum is one document which detail everything about the company. What are its assets? What are its liabilities? What is guarantors? What is employees? And this is the main step the IP has to prepare. Once he take over control, his main duty is to prepare information. That takes a considerable time. And based on this information memorandum, people are willing to give a revolution plan. If you don't have that information, you are stuck on the this step itself, and then you would be filing appropriate application against the promoter, saying they're not cooperating, they're not providing information. So this is the most crucial step, information memorandum, and it basically tabulate all the information about the corporate debtor. Here on your screen, if you see audited financial statement, list of the creditors, detail of guarantee, name of the address of the members, all litigation pending, all worker employees of the company. And once this is there, they have to appoint two registered valuer who then estimate the liquidation and the fair value of the corporate debtor. So that becomes a benchmark on which the lenders try to get the best deal. But this is never intimated to the counterparty, to the registered valuer. And there has been multiple changes in that. I'll come to that on a later time. So as I was saying that the job for IP is to find a buyer, and who can be the buyer? Revolution applicant, we call it, the one who submit a revolution plan for a corporate debtor. Technically, the term is revolution applicant. So the RP job is to find a revolution applicant. It is not that any Tom, Dick, and Harry can just walk out to IP and say that I am willing to buy this company. Initially, 29A was not there when the IBC came in 2016. It was lately found that in 1718, those companies which has defaulted because of that the company is into bad shape, they themselves buying through a revolution plan. Then the government felt, boss, it is basically defeating the purpose itself. Now, let's say I am now giving you a practical example. Try to understand. Now, company A had a 100 rupees value, and then with 100 rupees value, they took a loan of 100 rupees. So then the net value became the gross value 200. With a period of time, the profit was not there, the loss was there. And therefore, the value decreased with 20 rupees each year. Within last next 7 years, it depleted 140 rupees. Now the remaining value is 60 rupees. Okay. Now out of 200, the remaining value is 60. Now, with this 29A not there, the one who has actually brought it to 200 to 140 to 60 rupees, lost 140 rupees, he was able to buy out for 60 rupees. Then the government felt, was he is the main reason for that loss. How can we give that benefit to him? So therefore, this 29A was brought in, wherein it was an embargo that if you were a promoter of the company, then you will not be able to submit a revolution plan. But here it details about condition which are applicable for a 29A non-compliant party. Now, once this all initial procedure is done, he is taken over, IM is there, valuers are appointed. His job, IP job, is to find a buyer, and to find a buyer, the procedure is publish a Form G. Intimate the public by large that this company is for sale. You come and submit a revolution plan. So for that, there's a timeline, which is 75th day. He has to do that, and he has to publish in English newspaper, regional newspaper, website of a company. IBBA also has his portal wherein he has to publish, and then with he also has to publish event is nothing but now see for in the same example, let's say 60 rupees is the net value, but somebody can say I am happy to pay 6 rupees but 60 rupees, but I will be paying over a period of next 10 years. Then uh, see, he is paying 60, but somebody might be willing to pay 60 in the first year itself. So therefore, the value of the one who is paying you upfront is more higher. Because for one who's paying for a longer time, the discounting factor would kick in. For each year, let's say the discount factor of around 12%. So therefore, if he's paying over a period of 10 years, the with 12% discount factor, it will come to maybe we have to calculate, it will come to, let's say, 35 rupees. So his net value would be 35 against the one who is paying you 60. So that's how all these permutation, combination, discount factor, and what is guarantee he is giving, how much weightage we are putting, these all are providing the evaluation metrics. So this is very important because tomorrow some company can say, no, why are you giving preference to this buyer, why not to us? So that's how every scorecard is provided. It is basically in your exam sheet, somebody is saying that this question is for 5 marks, this is for 10 marks. And then it is for you how to navigate it through. So that's in nutshell evaluation metrics as for from a student standpoint, if I just explain that. And initially a request for revolution plan. A request for revolution plan, as I was saying, Form G is published. So initially, the interested party would submit a request for revolution plan, and then the job for the IP is to check whether they're compliant or not compliant, and then he will issue a provisional list within 10 days. The provisional list would be there. Any party who's contesting to that provisional list can give the objection in 5 days. And after those objection, the final list would come in next 10 days. So that's how the procedure is. Form G, provisional list in 10 days, objection 5 days, final list 10 days. So that's how it is. And then finally, who are eligible in the final list, they submit the revolution plan. So uh, before that, to come in the provisional list and final list, they have to uh, uh, be eligible as to submit the revolution plan, which is either they need to be compliant with section 29A and all the formalities asked by the IP. IP, it is, let's say, for 60 rupees company, somebody who may not have even 5 rupees in pocket say that I am willing to buy. But then IP has a trust that this person would be able to pay 60 rupees at a later time and would be able to run the company. So these all permutation combination are there in the eligibility criteria, which is given at the time of Form G. And I'll not come on to preferential undervalued. I'll come to that at a later time. So once now those who are eligible, they submit the revolution plan. So all those revolution plan which are compliant, they are tabled before the COC. COC, whosoever plan they like, with 66% votage, they can accept that plan. And then the job for IP is to give that revolution plan to the NCLT, say that COC members have agreed to sell this company to this revolution applicant, and therefore post that the NCLT checks whether that revolution plan is as per the terms of condition of the IBC or not. If the adjudicating authority, then the company move to a revolution applicant, he take over a control, happy ending. So that's in nutshell the procedure for the CRP. Now I am coming. CRP cost is nothing, the money spent by the RP during the CRP process. Now I am coming to the liquidation process. Uh, Mediator, should I take the question now or should I take at the end about the CRP part?
So, as you feel like doing, it's all on you.
Okay, so I'll take it at a later time. Let me just complete in next 10-15 minutes the liquidation process, and then we open the forum for question and answer.
Sure, sir.
Yeah. So as I was saying, the happy ending, but in life, you will also say that every ending is not happy. So when the happy ending is not there, the sad ending is liquidation process. So once the company is not taken over, nobody is willing to buy a company, then this company will get into the liquidation. Liquidation process, if in nutshell, I explain you now, the best value for a company is somebody who's willing to buy for a company, comes in and then buy a company. But if nobody is willing, then what to do? So for IP is to find out what all asset are there and then try to sell those asset either in piecemeal or either in slump sale, so that whatever value comes, then according to that value, he is able to pay to the creditors as per waterfall mechanism. What is waterfall mechanism? I'll come to that at a later time. Now, as section 33, where the adjudicating authority before the expiry of the CRP process reject or either reject the revolution plan. So let's say many people have, or one or two have submitted a revolution plan, but then NCLT find that it is not compliant with the IBC, then also the company will get into the liquidation process. Or members can themselves decide that we are not taking this company to a revolution, we are taking this company to a liquidation. Then also the company will get into the liquidation. These are the power and duties of a liquidator. He again does the same job, verifying all creditors, take into custody, control of the asset property. All that job is to be done again. And now the important parameter here is liquidation state. It is not that everything which is standing on the name of a company he would be able to sell. Some asset he has to put it aside from the liquidation asset. So whatever he is able to sell, that becomes a liquidation asset. You might have heard this term, liquidation asset state. It is the pool of asset which the liquidator can sell to get money, and that money can pay to the creditors. And there is an embargo on, let's say, some bankers in India. Whenever they're giving you some lendings, they always have a mortgage or charge, right? So at times when they find their asset which is mortgage to them against a loan has a more value than the pool value, so then they say, you don't sell our asset, we are keeping our asset aside, we will sell in surfacey. So then those assets are not becoming a pool of the liquidation state. That's in nutshell. Apart from that, there's a long definition. We are already running short of time. The asset not included in liquidation state is these, apart from the asset owned by the third party, which are not actually owned by the company, but in its possession because they were to supply it to third party and all that. Secured creditors in liquidation proceeding, they can, as I intimated, that sell it through Surface or realize those security, and then for the remaining part, they can come here. Now, distribution of the asset, this is very important. You might have heard this term waterfall mechanism quite a few times. Waterfall mechanism, it talks about that if any pool, any money is there with the corporate debtor, then how that pool would be distributed among the stakeholder. The first part, as you see, the CRP cost, any amount is spent for running this CRP process, the RP fees, liquidator fee, or the valuer fee, accountant fee, everybody's fees would be paid first, and then the workman dues, because government, in all the legislation that you might have read, the government gives a high priority to the workmen because they are the most affected and the most poor in the complete life cycle, in the complete pyramid. Then the bankers who have given the facilities and who has the charge of the asset. Then the employees. So there's a demarcation between the workmen and employees. So if we get into the corporate, it'll fall into the employee category. Our ranking would be C. We, by large, if I just give you the practical scenario, that both in resolution plan and also in the liquidation, money is distributed at B level itself. Nothing pass on generally to the C category. And post that E category also, F, they hardly get anything. The last is, of course, the equity shareholders who were running the show. So now, after the distribution of the asset, the company is dissolved. For winding up petition, means winding up is altogether a different procedure. Here it is very cut and short, that you sell on the asset, you pay it to all the creditors, and then you go for devolution. Devolution is the liquidator going to the NCLT saying that he has done his duty, and this company may be dissolved as per the A. Then adjudicating authority pass the order for devolution, and the company is dead, means it is striked off. Special transaction, as you will see, that see in journal parallels also, the biggest trades, it can be two scenario. One is because of economic scenario, technology change, new people change their lifestyle, and then the demand was not there for the good. The second is the promoter, he has siphoned off the fund, he has misappropriated the fund. These, they're special transaction. Now, as I was saying, that once the IP is appointed, his job is to take control and custody of the asset, and also watch what have transpired in the last 2 years, 3 years. When he find that something fishy has happened, then he has to appoint a special transaction auditor who would do the complete scrutiny of the book of account and try to find out whether any money was siphoned off, whether any preferential transaction was there, whether any undervalued transaction was there, whether any fraudulent transaction was there. If any of these transactions are found by the transaction auditor, or by the forensic auditor, then RP is bound to file an appropriate application to the NCLT intimating NCLT that this much money has been siphoned out by these promoters or by any third party. So then NCLT job is to adjudicate on those application and decide whether that has a material or not. If that has a material, then they have to pay this much amount, and also then there's a jail for them custody. So here it is a preferential transaction which is under section 43. Any preference given to one set of creditor over the other, that's preferential transaction. Undervalued is you're selling it, let's say your for a company, what is assets? It's a tangible asset and also the goods. Let's say the value of the goods was 100 CR, then it's sold it to somebody for 40 CR who just wanted to pass some benefit to the other guy. And then that was a under value transaction because that has caused the loss to the company for 60 CR. Then the RP job is to find that transaction and then file appropriate application to the NCLT. Defrauding creditors, the same way any transaction you find defrauding creditors or extortionate credit you have taken. So that's all in with regard to the liquidation. So in nutshell, if I just again speak, liquidation is selling asset and then giving it to the creditors and then filing an appropriate application to the NCLT for dissolution. That's how it is. But in practical, it takes approximately 2 years because the main challenge that I see is to find the right buyer for a particular asset. Uh, for a small company, let's say a paper company or a small company of around 1 CR, 2 CR, 10 CR, the process generally take us very lesser time. But when it comes to 1,000 CR company or 10,000, then because there are a lot of stake involved, you cannot just simply sell. If somebody is not coming, then you have to again go for public announcement. That also take time. Then you have to wait for particular duration. And if somebody is not coming, then you have to reduce the bid amount. So that's all theoretical part. And I just let me just take out to you all to the IBBI website. Just give you a kind of brief means how you can navigate it further and what meaningful you can find it for yourself. Now, see, if you want to get into the IBC space, one is you would be starting on your own, but the second is uh, see, initially nobody, if you start on your own without learning, then nobody takes you seriously. So to get on to some firm which are already there, you go to the service provider, see all those insolvency professional entities or IPs. You can now this is the list of IP. Their email ID, everything is there. You want to find opportunity, just apply to them. If they like it, then perhaps that's how it is. And to give you very meaningful, means that was meaningful from the job standpoint, but from learning standpoint, this is the homepage. A corporate process, IP corner, employee corner. So these red and green is not applicable for you.
So sorry to interrupt, but the website is not visible. We are able to see the last screen of the presentation.
Oh man, you okay, again into that. Should intimate me at the right time. Okay, I am putting my entire screen. I think this is the best option. Yeah. So now I think it should be visible. Huh? I put on the entire screen.
Yes, sir. Now it is visible. Thank you.
So yeah. Now service provider, it might be of more relevance to the youngsters. So here who are working in India and the IP entities. These are the list of IP entities. You find out their location and details, who is heading the show, and then you can find your job prospects here. There, how many IPs? I think more than 200 IP entities are there, and in India, more than 3,000 IPs are there. But the bad part, though, I have given you this PPT in with a great idea and hope But IBC, at least from the last 2 3 years, is on the downside. The main reason, see, when this IBC came in 2016, prior to that, when it was thought of, 2014, the gross NPA for a country was approximately 8 to 10% of the GDP. But now just Google it. I think it is approximately 2 to 3% of the GDP. So the banks at this juncture in India are sitting at the best of its best time. They never had that best time. And therefore, the requirement for this IBC has fallen down actually. Uh, the banks are not moving more application because there are already no NPA, at least from the magnitude I'm talking about. And therefore, on the practical job aspect side, it is not a growing field. It is on rather on the declining phase. That's true, and I just don't want to sell the dreams. So that's the reality for the IP part. And for you, because at times people are surrounding you. I was also a law student once upon a time, is 14 years back. So people say that this your colleague or your friend, your relative might have filed a particular claim against some company, and they want to understand what this company is getting into, what is the process. So with that, you come to the process, corporate process. You click on this, and here everything. Just put the name of the company, is public announcement to claim, to invitation, the revolution plan, auction. Everything will come flashy here. So this is your go to. And apart from that, this is the, with regard to the board, this may not be of relevant, and this is the best thing. So now if you want any statute with regard to IBC, you come to this one, because apart from other government website, IBBI is very updated, in the sense they keep on updating their act, rules, regulations, circular, everything. Whatever latest you want to check it here. And media and everything may not be of much relevance, but of course, publication, if you want to get into understanding of the IBC, I will say just download 2 3 quarterly newsletter. It's very good. It give you idea what IBBI is doing, what are the judgment passed by the Supreme Court on IBC, what are the few prominent judgment passed by the High Court on the IBC, which all IP have been um, debarred from practicing, which are IPs. So everything you'll find in the quarterly newsletter. When I started, it was a best thing that I would read. And of course, order, you want to find out it, you can go to the order. I think that was all what I wanted to explain from my side. Uh, yeah, please, you can now, we can open the forum for a Q&A. Hi, we
Participants, if you have any questions, you are free to ask, and you can unmute yourself as well.
I'm sorry, this camera was not working because I wanted to plot in through the other camera, laptop, but then it was PPD was not coming in. My apologies for that.
No
Yeah,
problem, sir.
Hadi, you want to ask something?
Yes,
Please.
sir. I wanted to ask that what is the time period for the approval of the resolution plan?
See, uh, now the plan has to be approved by the NCLT, right? No, initially before that, the plan has to be approved.
Resolution plan is like submitted to the RP, right? So will it directly go to NCLT or
No, no, no,
COC will
no, no.
approve it?
I tell you. Now, there would be multiple plans given by a resolution applicant. There may be 10 resolution plan, and then there may be 5. So IP job is to find which are the compliant resolution plan. Then he has to place all those compliant resolution plan before the COC. So in the
Okay.
first header, it is a COC which is approving. There is no regulation which says that in how much time the COC has to approve, right? There's no.
Okay.
So they
Okay.
generally, if I give the practical scenario, in large account, they take approximately 2 to 3 weeks.
Okay.
And
So,
you can
suppose the internal memorandum. right, which was floated earlier while the auction process and everything.
The
If
auction
there
is
is
entirely a different ball game. Auction, we talk
of the
about the liquidation.
company. Hello?
Hardy, the
Yes, sir.
auction, yeah, auction nomenclature will trigger in when you're
Hmm.
talking about the liquidation.
Correct.
Here we're talking about the revolution. So in CRP process, it took the revolution. So when revolution plan
But
is
sir,
there,
in
the COC
liquidation
approved.
process also they ask for a resolution plan.
Yes, I am coming to that. I am
Okay.
coming to that. So now in the CRP, the nomenclature of revolution plan, not the option. So a revolution plan, once it approved by the COC, IP job is to put it to the NCLT. Now you are right.
Hmm.
In liquidation, also the term revolution is plan is there. So initially, it was a slum sale auction only.
Hmm.
Post that, the regulation changed in 2022, wherein it was brought in by the IBBI board that to fetch the best value, to fetch the best value, IP, even in liquidation, he should try to get a revolution plan.
Okay.
Yeah.
So
So
there is no time limit.
no, no, no. So once it is 90 days, 90 days for the revolution plan, but many IPs, what they do, even with revolution plan, they're also putting the auction notice. Some are doing auction after the revolution plan.
Correct,
Yes.
correct, correct.
Yeah, that's
So,
the IP
sir,
prerogative.
my only query is that in internal memorandum there is time specified for payment and everything, right?
Yes, yes.
But what if they do delay in approving the resolution plan? Then how will the payment method
Yes,
and
yeah,
everything
yeah.
will go on?
That is the practical scenario. So
Yeah.
here also, you are into practice side, okay?
Yes, sir.
So that's how, because a student will not ask those questions. So in practical,
Okay.
because I've done this process quite a few times, so that's a practical difficult. What now to answer to that? You put on the particular time duration in the revolution plan, so that let's say 30 days for the only revolution plan. If no revolution plan, then the option. So that's the best way. But otherwise, what the IPs are doing
They are not approving it.
together, and then the confusion. So
Correct,
then
correct, correct.
any other, yeah.
Then it will be in contravention with the internal memorandum and everything.
Yes, yes. So that's
Hmm.
how it is. You put the nomenclature or timeline where you state initially 30 days only for revolution plan. If it fails, then option.
Okay, okay, okay. Thank you so much, sir.
Yes, Seema has raised her hand. Please go ahead, Seema.
Yeah.
Then
Sir,
Purvi is
first,
also there post that. Yeah.
yes, sir. First of all, thank you so much for that insightful session. It was very quick, very thoughtful, and comprised of all the relevant provisions. Although it's difficult to absorb in such a
Yeah,
short
that's
time,
what
but
I wanted to just give you overview.
yes,
And
overview. Yes, understand. My question is, in practice, the timeline which IBC code has given, I think in practice we are nowhere to achieve that timeline. What would you say on that?
see now, see IBBI is a governing body, right? A governing body or the government, any organ of the government, it cannot dictate the terms to the judiciary. Judiciary is judiciary. Boss. So even in many aspects, let's say the timeline for deciding a CRP application, it was initially 14 days, but now practical scenario 6 months. How the Supreme Court interpreted that this is a kind of indicative timeline given to the NCLT, but NCLT can take its own sweet time, and that sweet time is 6 months to 1 year. They deliberate on that and see. Now, I was saying this practice is falling. It's only because of NCLT, because bankers believe that within 6 months, 1 year, the revolution should happen. NCLT is sitting for 6 months, 1 year, deciding the plan. Bankers have to pay the cost. Therefore, they're
Correct.
feeling, boss, this is not a good ride. Let's go for OTS. This is a real hard truth of the today's time.
Correct. Yeah.
Yeah,
Thank you.
please, Purvi, you want to go ahead, please?
Thank you.
Yes, sir. Good evening, sir. Am I audible?
Yeah, yeah, you're audible.
Yes, sir. My name is Purvi and I am planning to pursue CS alongside law. My question is, as you are a CS2, how do you see the role of a CS evolving under IBC in the next few years? And what opportunities and specific skills should an aspiring CS watch out for? And it is a little bit open-ended question, so please
Yeah.
advise regarding this.
So,
Thank you.
see, Purvi, if I see now, always people see grass is on greener on the other side, and it's always good to live on the dreams. But the reality can be other way around. So, what I've seen from the practical standpoint, though if you read out the IBC, you'll find that this is more on the legal side. This is purely a law. It is not a chartered accountant game, but on the practical side, you see most of the big four and other firms, they have the chartered accountant who are doing the IBC practice. And rarely you will find a company secretary doing the IBC practice, leading the IBC practice. There are few. I am also one because of my CS and law. But by and large, it's a chartered accountant dominated field. The CS are there who are doing form filling, regulatory part by and large, which is not too much. It is maybe marginal. If I say a filing has to be done and then CS is the guy. So that's the practical standpoint. Future, as I say, this is on this practice itself on the declining phase. I am not too sure how you should take it ahead. If you any other question, yeah,
I see. Thank you
please,
so for your insight.
yeah, thanks.
Thank you so much, sir. It was a great lecture.
Yeah, thanks. Somebody want to raise a hand or should we end up?
Thank you so much, sir.
Yeah, no. Thanks.
If, if possible,
Thank you, sir.
kindly share PPT. And actually, in the early time, it was not changing the slide.
Yeah. That's see, I wanted to switch the. My apologies for that. And yeah, what I
So
can
no
say.
problem. If possible, kindly share it, please.
Yes.
Thank you so much.
Kedar Nayak, you have raised your hand. Please go ahead.
Sir, can you please shed some light over the concept of acknowledgement of debt by the corporate debtor?
Acknowledgement of a debt. Yeah, this is. I think you are purely a legal guy from the question I can make out. So acknowledgement
Yes.
of debt is very important. This is now you can file an appropriate application in the recovery suit on the acknowledgement. Let's say company X has to pay you 100 rupees. They are not giving you 100 rupees. For you, the way out is to file a recovery suit in the district court or in the commercial court, right? And with acknowledgement on that, out of those 100 rupees, they have given an acknowledgement on 20 rupees. Now you can file a separate application saying that at least out of 120 they have acknowledged. Let the court ask them to pay that 20 upfront. So that's the beauty of acknowledgement. And in IBC, if you wanted with financial creditors, the banker's book of accounts are considered as acknowledgement. But from the operational standpoint, if any operational creditor has given you goods or services, then the acknowledgement of the due has to be done by the corporate debtor to get the case admitted against the corporate debtor. Otherwise, the case will not be admitted. The corporate debtor can say that though they have given me 100 rupees goods or services, but I am not acknowledging the debt. I have given them findings that these were deficiency in the goods or services. I have returned. Therefore, there is no acknowledgement. I am not bound to pay them 100 rupees. And on that pretext, the NCLT would then decide. You have again raised your hand, I think.
Also, sir, if in a situation where the corporate debtor has been part of an arbitration proceeding,
No,
and
yeah. So award works as acknowledgement.
so, sir, my this question is my second question. So, if at all there's an arbitration award against them, wherein they are supposed to abide by the arbitration award, but
Yeah.
before it can be enforced, the CIRP process begins, and then the company uh, like
Yes, understood. Then see on
basically
that
goes through
basis.
the resolution process,
Yeah.
and
So
ultimately it goes to someone else. So in that scenario, an unenforced arbitral award, what happens to it, sir?
yeah. So once you have an award in your favor, the only thing that you can do during the moratorium is to file a claim based on that award. Post
Okay,
that,
sir.
that if the company has moved up from the revolution and company has gone for liquidation, then you can on that basis you can again file a claim. So for even to get an award, people by large they ask me that we want to proceed against this company. It is already into IBC. मैंने कहा, boss, you would be spending money to an advocate, and even if you get an award, this hardly serve any purpose.
Understood, sir.
Yeah.
Yes, sir. Thank you.
Yeah, thanks, Tudor. Uh, there's a long name. I'm not able to. Please, Rasithia Malaya, Maidrisu, please go ahead. You got to unmute yourself and
Uh,
then,
yes,
yeah.
sir. Thank you so much, sir. So, can we have this recording, sir?
I wasn't recording this session. If anybody from the legal Vidya has done that, then perhaps they can share with you. I
Okay,
have
sir.
no.
So the recording will be shared in the group itself.
Okay,
I
okay,
think
ma'am.
you have a clue.
Thank you so much, sir.
Yes.
Any other question, Khushbu? Should we call it off or what?
Yes, so we can wrap up.
Yeah, I think Samit has just joined. Okay, then thanks everybody for joining the session. It was very good to hear feedback from you, and then my apologies with regard to camera and all that. So next time we'll do in a better way. But thanks. Any apart from that, I practice on this vertical. You want to connect me offline? I'm always available. Thanks.
Thank you so much, sir, for such an insightful and engaging session. I'm sure everyone here has already gained a lot of valuable knowledge. And to all the participants, thank you for your energy and focus today. Hope we all soon meet again in another interesting session. Until then, stay curious, keep learning, and take care. Have a great evening, everyone. Thank you.
Thanks everyone. Yeah.
To my thanks.